If you're over 60, an immigrant, a green card holder, or weren't born a U.S. citizen, listen carefully. A new banking rule coming in 2026 could completely upside down your financial life, and I'm not exaggerating. This isn't another boring regulatory update you can ignore. This is a massive shift in how the U.S. government tracks and enforces rules about your foreign bank accounts, and it specifically targets seniors and immigrants in ways we've never seen before. Picture this. You have a small savings account back in your home country. Maybe it's got $8,000 sitting there. You opened it decades ago. You use it once a year when you visit family. You haven't even thought about it because the amount seems so tiny. You've been filing your taxes honestly every single year. You figured this little account doesn't matter to the IRS because it's so small and you barely touch it. Then one day in 2027, you get a certified letter from FinCEN, the Financial Crimes Enforcement Network. It says you failed to report a foreign financial account. The penalty? $30,000. Your U.S. bank accounts are frozen. And if you're applying for citizenship or renewing your green card, your entire immigration case is now in serious jeopardy. That's not a scare tactic. Under the new 2026 rules, this exact scenario is going to become shockingly common unless people understand what's changing right now. The good news is nothing I'm sharing is meant to frighten you unnecessarily. My entire purpose is to prepare you. If you know what's coming, understand the new requirements, and follow a few simple steps, you can protect yourself completely. You can avoid penalties, avoid audits, and avoid problems with your immigration status. I'm going to walk you through exactly what this new banking rule is, who it affects, why seniors and immigrants are being singled out, and most importantly, what you need to do right now to stay safe. By the end of this video, you'll know if these changes apply to you, and you'll have a clear action plan you can start today. I'm George from Dream Visa Updates, and I've spent years helping seniors, immigrants, and green card holders understand complicated U.S. financial regulations and immigration rules in ways that actually make sense. I know how overwhelming this stuff can feel, especially when you're on a fixed income or dealing with the stress of immigration paperwork while building a new life in America. Most people just want to follow the rules, support their families, and live in peace. But when the government suddenly changes something important without making it clear, it creates confusion, fear, and terrible consequences for honest people who never meant to do anything wrong. That's why I'm here. I'm not going to use legal jargon that makes you feel stupid. I'm explaining these new rules in plain English so you can make informed decisions about your situation. Let's start with the most important question. What exactly is this new banking report rule? Starting with the 2026 calendar year, meaning the reports you'll file in early 2027, FinCEN and the IRS are launching what they call the Enhanced Foreign Account Mandatory Reporting System. This is a massive expansion of existing foreign bank account reporting requirements, and it introduces several changes affecting millions of people who never had to worry about these rules before. Here's what you need to understand. First, the reporting threshold for foreign bank accounts is being dramatically lowered, and this lower threshold applies specifically to two groups: seniors over age 60 and anyone who wasn't born a U.S. citizen. Under the old system, you only had to report foreign bank accounts if the total combined value of all your foreign accounts exceeded $10,000 at any point during the year. That threshold stays in place for younger people born in the United States. But for seniors over 60 and immigrants, the new threshold drops to just $5,000. In some cases, depending on your immigration status or citizenship application timeline, it could drop even lower to $3,000. Second, the definition of what counts as a foreign financial account is being expanded. It's no longer just regular checking and savings accounts. The new rules also include foreign retirement accounts, foreign pension funds, life insurance policies with cash value, prepaid debit cards issued by foreign banks, digital wallets held with foreign financial institutions, and even partial ownership interests in foreign properties or businesses if those interests generate any financial return. Simply put, if you have any money, any asset, or any financial connection outside the United States with any value at all, it probably needs to be reported under the new system. Third, and this is perhaps the most significant change, FinCEN, the IRS, and USCIS are now implementing complete real-time data sharing. What does that mean practically? Every piece of financial information you report to the IRS will be automatically cross-checked against records from the Financial Crimes Enforcement Network, and all that information will be immediately accessible to U.S. citizenship and immigration services. If there's any inconsistency, any missing information, or any account that appears on one agency's records but not another, the system generates an automatic notice. In many cases, it triggers an immediate investigation. There's no longer any chance of something slipping through the cracks or being overlooked because it seemed too small. Fourth, the new system eliminates almost all exemptions that used to exist for small accounts, inactive accounts, or accounts jointly held with family members. Under the old rules, many people avoided reporting certain accounts because they fell into special categories. Those categories are disappearing. Starting in 2026, if you meet the age or citizenship criteria and you have any foreign financial connection above the new lower thresholds, you must report it. Period. No exceptions for accounts you rarely use, accounts you share with aging parents, accounts you opened decades ago and forgot about, or accounts that only hold a few $1,000s. Now I know what you're thinking. Why are seniors and immigrants being singled out? Why is the government creating different rules for different groups? The official explanation from FinCEN and the IRS is straightforward, even if it feels unfair. According to multiple government studies over the past 5 years, seniors over 60 and immigrants are the two demographic groups most likely to have unreported foreign financial accounts, not because they're trying to hide anything, but simply because they don't understand the reporting requirements. Let me explain. Seniors, especially those now in their 70s, 80s, or 90s, often lived internationally mobile lives. Many retired abroad for periods and then returned to the U.S. Many worked overseas during their careers and accumulated savings or pension benefits in other countries. Many maintained bank accounts in their countries of origin to make it easier to visit family, pay for medical care, or handle estate matters. From their perspective, these accounts are just practical conveniences. They're not trying to evade taxes or hide money. They simply never realized that U.S. law requires reporting of worldwide financial assets, regardless of where those assets are located or how small they are. The same pattern applies to immigrants and green card holders. Millions of people who move to the United States maintain financial ties to their home countries. They keep bank accounts open to support elderly parents. They hold on to small retirement savings from jobs they had before immigrating. They own partial interests in family homes or small businesses. They may even receive modest pension payments from foreign social security systems. To them, these financial connections have nothing to do with their lives in America, but under U.S. tax law, they absolutely do. The problem is many immigrants simply don't know this, especially if they came to the United States later in life or English isn't their first language. So instead of relying on people to somehow discover obscure reporting forms on their own, the government decided to make it impossible to miss. By lowering the threshold specifically for seniors and immigrants and placing new mandatory questions directly on standard tax and banking forms, FinCEN and the IRS are eliminating any excuse of "I didn't know." And by creating automatic data sharing between agencies, they're making it nearly impossible for unreported accounts to remain hidden. Before we go further, if what you're hearing is new information that concerns you, take 1 second to like this video. The more people who like and share this, the more seniors and immigrants will see it before they accidentally get themselves into serious trouble. These rule changes are complicated, confusing, and the government isn't doing a good job explaining them in ways ordinary people can understand. By liking and sharing, you're literally helping protect people in your community. Now let's talk about how these new rules affect different groups, because the impact isn't exactly the same for everyone. If you're a senior who was born in the United States and always been a U.S. citizen, you might think this doesn't apply to you. That assumption could be very dangerous. Under the new requirements, any person over age 60 who has any foreign financial connection will be required to answer enhanced reporting questions on their annual tax return. If you receive even a small pension from another country, have a bank account overseas, own any part of foreign property or investments, or maintain any foreign financial account for any reason, you'll now be required to disclose that information in much greater detail than ever before. The IRS is no longer treating foreign assets as something only wealthy people need to worry about. Under the new system, even a small dormant account with $3,000 will trigger reporting requirements if you're over 60. Even an account you only use once a year when you visit family abroad will count. Even accounts jointly held with siblings or aging parents need to be reported if you have any access to them or any signature authority over them. The assumption built into the new system is if any foreign financial connection exists, it must be reported properly, completely, and in detail. For green card holders, the situation is significantly more serious. As a lawful permanent resident, you're already required to follow the same tax and financial reporting rules as U.S. citizens. That's always been true. But what makes the 2026 changes especially critical for green card holders is the direct connection between financial compliance and immigration status. When you apply for U.S. citizenship, USCIS conducts a thorough review of your tax history as part of what's called the Good Moral Character requirement. Under the new enhanced data sharing system, USCIS will have immediate automatic access to all your IRS and FinCEN records. This means immigration officers will be able to see whether you correctly answered the foreign account questions on your tax returns. They'll see whether you filed all required foreign account reports. They'll compare the information you provided on different forms and identify any inconsistencies, missing details, or accounts that weren't properly disclosed. Here's the critical point. Even if your failure to report was completely unintentional, even if you simply didn't understand the rules, that mistake can still create serious problems during your citizenship application. It doesn't necessarily mean your application will be denied, but it absolutely can trigger delays, additional questioning, requests for more documentation, and in some cases, referrals for further investigation. In the most serious situations, repeated or significant failures to comply with financial reporting requirements can be used as evidence that you don't meet the good moral character standard, which can result in denial of citizenship. That's why green card holders need to be extremely careful, extremely thorough, and extremely proactive about complying with the new reporting requirements once they take effect. If you're a naturalized citizen, you might assume that because you're now fully American, these special rules no longer apply to you. Unfortunately, that assumption is incorrect. The new regulations specifically include naturalized citizens in the enhanced reporting group. The reasoning is straightforward. People who weren't born in the United States are statistically far more likely to maintain ongoing financial relationships with other countries even many years or decades after becoming U.S. citizens. So even though you have exactly the same legal rights and responsibilities as any other American citizen, you'll still be subject to the lower reporting thresholds and the enhanced monitoring that applies to immigrants. And finally, for those in the United States on work visas, student visas, or other temporary immigration statuses, these rules can matter just as much. If you meet the substantial presence test for U.S. tax purposes, which most people on long-term visas do, then you're required to file U.S. tax returns and comply with all financial reporting requirements. For visa holders who hope to apply for green cards in the future or may eventually want to become citizens, your tax compliance history matters enormously. Problems with IRS or FinCEN reporting can complicate visa renewals, create issues during adjustment of status applications, and even be used as grounds for denial of immigration benefits. So to summarize, the new 2026 banking report rules reach far beyond just retirees. They touch almost anyone who has lived, worked, or maintained family connections across more than one country, and the consequences of failing to comply can range from significant financial penalties all the way to serious immigration problems. Now we come to the most important question. What should you actually do to protect yourself? Instead of worrying or feeling overwhelmed, the smartest thing you can do is take a few practical steps right now, today, before these new rules take effect. I'm going to give you a clear step-by-step action plan that will keep you safe. Step 1. Immediately create a complete inventory of every foreign financial connection you have, and I mean everything. Sit down with paper or open a document on your computer and make a detailed list. Write down every foreign bank account, no matter how small. Include accounts that are mostly empty or you haven't used in years. Write down any foreign retirement accounts or pension funds, even if you're not currently receiving payments from them. List any life insurance policies issued by foreign companies that have cash value. Include any ownership interests in foreign property, even if you only own a small percentage and the property doesn't generate rental income. Write down any foreign investment accounts, brokerage accounts, or business interests. For each item on your list, record the name of the financial institution, the country where it's located, the approximate account balance or value, and whether the account is in your name alone or jointly held with someone else. If you have old statements or documents, gather them and keep them together in one place. Many people get into terrible trouble simply because they never took the time to organize this basic information. Doing this one step now while you still have time can save you from enormous stress, massive penalties, and potential immigration problems later. Step 2. Review your past FBAR filing history immediately. The FBAR, which stands for Foreign Bank Account Report, is not a new requirement. It's existed for many years. The rule is simple. If the total combined value of all your foreign financial accounts exceeds $10,000 at any point during the calendar year, you're required to file an FBR electronically with FinCEN by April 15th of the following year. This requirement applies even if each individual account is small. For example, if you have 3 foreign accounts with $4,000 in each one, the total is $12,000, which means you must file an FBAR. Here's the problem. Millions of seniors and immigrants have never filed FBARs because they simply didn't know the requirement existed. If you're realizing right now that you should have been filing FBARs for the past several years but didn't, don't panic, but also don't ignore it. The IRS and FinCEN offer what are called streamlined filing procedures that allow people to come into compliance with reduced penalties if they can demonstrate their failure to file wasn't willful or intentional. The absolute worst thing you can do is realize you have a problem and then do nothing, hoping it will somehow go away. It won't go away. And under the new 2026 system with automatic data sharing and lower thresholds, unreported accounts are going to be discovered. Taking action now to voluntarily correct past mistakes is infinitely better than waiting for the government to find the problem first. Step 3. Begin preparing for the new 2026 reporting requirements right now. Because the thresholds are dropping to $5,000 or lower for seniors and immigrants, many people who never had to file detailed foreign account reports before will suddenly be required to do so. If you believe your foreign financial assets might exceed the new lower limits, start collecting documentation immediately. This means gathering bank statements, account balance confirmations, and records that show the highest value of each account during the year. You'll also need to convert foreign currency amounts into US dollars using the appropriate exchange rates for the dates in question. This can be time-consuming and complicated, especially if you need to contact foreign banks or financial institutions to obtain old records or balance confirmations. Waiting until the last minute during tax season will make this process incredibly stressful and difficult. But if you start now while you still have plenty of time, you can gather everything you need in an organized, methodical way without pressure or panic. Step 4. Make absolutely certain you're correctly reporting all foreign income you receive. This is especially critical for seniors who receive pensions, annuities, or Social Security type payments from other countries. Many people make the dangerous assumption that because their foreign income is already taxed in the country where it originates, they don't need to report it on their U.S. tax return. That assumption is almost always wrong. U.S. tax law requires you to report your worldwide income regardless of where it comes from and regardless of whether it was already taxed somewhere else. Some countries have tax treaties with the United States that can reduce or eliminate double taxation, but those treaties don't eliminate the reporting requirement. You still must disclose the income on your tax return to claim treaty benefits. Under the new 2026 rules, there will be specific mandatory questions on the standard tax return asking about foreign pensions, foreign Social Security benefits, and other foreign income sources. These questions won't be optional, and leaving them blank or answering them incorrectly will trigger automatic notices and potential investigations. If you're unsure about how to properly report foreign income, or if you're not sure whether a tax treaty applies to your situation, this is the time to speak with a qualified tax professional who has specific experience with international tax issues. Trying to figure this out on your own or guessing can lead to serious mistakes that will be very expensive to fix later. Step 5. Keep organized, detailed records of absolutely everything related to your tax and financial reporting. This means saving copies of your completed tax returns, copies of any FBARs you file, copies of any other foreign account reports, and copies of all supporting documents like bank statements, balance confirmations, and currency conversion calculations. Store these records in a safe, organized place where you can easily find them if needed. This step is particularly important for green card holders and anyone planning to apply for U.S. citizenship in the future. During the naturalization process, USCIS may ask you to provide proof that you've complied with all tax filing and financial reporting requirements. If you have well-organized records that clearly show you filed everything correctly and reported everything honestly, the interview process can be simple and straightforward. But if you can't easily produce documentation or your records are disorganized and incomplete, what should be a routine question can turn into a major problem that delays or even derails your citizenship application. Many immigration cases get delayed or denied not because the person actually did anything wrong, but simply because they couldn't prove they did things right. Good record keeping is one of the easiest and most effective ways to protect yourself. Now, to help you understand why all this matters so much in real life, let me share a story that illustrates exactly what can happen when people aren't prepared for these kinds of rule changes. This is a real situation that happened to someone I helped, and I'm sharing it so you can see the consequences in concrete terms. Maria is a 72-year-old woman who immigrated to the United States from the Philippines nearly 30 years ago. She became a permanent resident, worked hard her entire life, and retired on a modest Social Security income. In the Philippines, she kept a small savings account with about $8,000 in it. She used this account maybe once a year when she traveled back home to visit family and pay for medical care for her aging mother. From Maria's perspective, this account was completely separate from her American life. It was a small amount of money in a faraway country, and she never thought it had anything to do with her taxes or immigration status. Maria always filed her tax returns honestly every year. She reported her Social Security income. She took her standard deduction. She never owed any taxes because her income was so low. She had no idea she was supposed to file an F-bar or report her foreign bank account. Nobody ever told her. The forms and instructions were buried in complicated IRS publications she never saw. For nearly 15 years, she filed her taxes the same way every year, and nothing ever happened. Then in 2026, the new rules took effect. Maria filed her tax return the way she always did, but this time the return included new mandatory questions, specifically asking whether she had any foreign bank accounts. Maria didn't really understand the question and was afraid that if she answered yes, it might create problems, so she left it blank. A few months later, she received a letter from FinCEN. The letter explained that under the new data sharing agreements, foreign banks are now required to report account information for U.S. persons to the U.S. government. FinCEN had received information showing Maria had a bank account in the Philippines she hadn't disclosed. The letter demanded she immediately file corrected tax returns for the past 6 years, file F-bars for all those years, and pay penalties for failing to report. The initial penalty calculation was over $30,000. Maria was terrified. She didn't have $30,000. She lived on less than $1,800 a month from Social Security. She tried to explain she didn't know she was supposed to report the account, but the letter said lack of knowledge wasn't a valid defense. To make matters worse, Maria had recently applied for U.S. citizenship. Her naturalization interview had been scheduled, but when USCIS accessed her IRS records and saw the FinCEN enforcement action, they put her citizenship application on hold pending resolution of the tax issue. Maria ended up spending nearly $10,000 on attorneys and accountants to fix the problem. The process took more than a year. Her citizenship was delayed. She spent months terrified she would be deported or lose her green card. Eventually, her lawyers were able to use the streamlined procedures to reduce the penalties and prove her violations weren't willful. She finally became a citizen, but the entire experience was traumatic, expensive, and completely avoidable. If Maria had known about these rules earlier, if she'd taken the time to organize her information and file the correct forms, the entire nightmare could have been prevented. That's exactly why I'm making this video. I don't want you to go through what Maria went through. Now let's address some of the most common questions seniors and immigrants ask me about these new rules, because I know many of you are probably wondering about specific situations. Question 1. Do these new rules affect regular U.S. bank accounts or Social Security benefits? The answer is no. The 2026 changes only apply to foreign financial accounts and foreign income sources. Your regular checking account at Bank of America, your savings account at a local credit union, and your U.S. Social Security benefits are completely unaffected by these rule changes. Nothing about those accounts or benefits is changing. What the new rules do affect are things like bank accounts in other countries, pensions from foreign governments, retirement accounts managed by foreign financial institutions, and foreign Social Security type payments. If you receive retirement benefits from a government or employer outside the United States, those payments are generally considered taxable income here unless a specific tax treaty says otherwise. The new mandatory questions will specifically ask about these foreign income sources, which means you'll need to report them accurately instead of ignoring them or assuming they don't matter. Question 2. What if I have a foreign account that's basically empty or I never use anymore? Do I still have to report it? The answer is yes. Under the new rules, even dormant accounts, even accounts with very small balances, and even accounts you haven't touched in years still count toward the reporting thresholds. If the combined total of all your foreign accounts exceeds the threshold amount at any point during the year, even for a single day, you must report all of them. You can't pick and choose which accounts to report based on how active they are or how important they seem to you. The requirement is to report everything. Question 3. What about accounts jointly held with family members? Do those count? Yes, they absolutely do. If you have signature authority over an account, or if you have the legal ability to access the funds in an account, it counts as your account for reporting purposes, even if other people's names are also on the account. This is a very common source of confusion. Many seniors have joint accounts with aging parents, adult children, or siblings specifically to help manage family finances. But under U.S. law, if your name is on the account or you can access the money, you must report the account, even if you never actually use it, and even if most of the money belongs to someone else.